Welcome, everyone, to this, the 11th session of our book club, Reasoned Argument, the Counter to Cancel Culture. Tonight, we're going to be talking about, or listening more to, the speeches by Lincoln and by Frederick Douglass. In terms of the format, it'll be a little bit different. I'm not going to use the three think points. I'm just going to pretty much divide the hour between those two. But let me just give a brief introduction, and then we'll go right into Lincoln. So you may remember from an earlier session when I was introducing the subject of rhetoric and the Ciceronian background that many of the rhetoricians, orators had in the United States. That is, they were well educated and they were largely privileged. But now, as I indicated back then, two of the greatest orators had no such background. They were not privileged. Lincoln, known to some as white trash, and Frederick Douglass, a former slave. They're both self-educated. And as I said before, they both worked on rhetoric out of the same book called the Columbian Orator. And it's available apparently on Google Books at no cost. So if you want to give your children a better education than probably they're getting, you might want to look it up. In any event, we're going to turn now to Lincoln's speech in 1838. It's called the Lyceum speech. This speech is called the Lyceum speech because he's speaking to the young men's Lyceum. And so what is a Lyceum? In classical Greece, it referred to the school of philosophy of Aristotle, and I guess of others as well, that was traveling around. So in modern, or at least 19th century America, it would have referred to secondary education, apparently. So in this speech, he is very much concerned about the situation of the country. And it's not just about slavery. In fact, there really isn't a direct reference to slavery in the speech. Remember that Lincoln is a very big fan of Henry Clay, apparently after whom he models himself, at least for a time. And Clay has pulled off this wonderful compromise in 1833. This is 1838, and he's very disturbed about the condition of the country. And what is it? What are the dangers? Well, in this first part of it, it'll be the danger that many of you have heard before, that if the United States is ever to be conquered, it won't be from without, it will be from within.
As a subject for the remarks of the evening, the perpetuation of our political institutions is selected. We find ourselves in the peaceful possession of the fairest portion of the earth, as regards extent of territory, fertility of soil, and salubrity of climate. We find ourselves under the government of a system of political institutions conducting more essentially to the ends of civil and religious liberty than any of which the history of former times tells us. We, when mounting the stage of existence, found ourselves the legal inheritors of these fundamental blessings. We toiled not in the acquirement or establishment of them. They are a legacy bequeathed to us by a once hardy, brave, and patriotic, but now lamented and departed race of ancestors. Theirs was the task, and nobly they performed it, to possess themselves, and through themselves us, of this goodly land, and to uprear upon its hills and its valleys a political edifice of liberty and equal rights. 'Tis ours only to transmit these, the former unprofaned by the foot of an invader. This task of gratitude to our fathers, justice to ourselves, duty to posterity, and love for our species in general, all imperatively require us faithfully to perform. How then shall we perform it? At what point shall we expect the approach of danger? By what means shall we fortify against it? Shall we expect some transatlantic military giant to step the ocean and crush us at a blow? Never. All the armies of Europe, Asia, and Africa combined, with all the treasure of the earth, our own excepted, in their military chest, with a Bonaparte for a commander, could not by force take a drink from the Ohio, or make a track on the Blue Ridge, in a trial of 1,000 years. At what point, then, is the approach of danger to be expected? I answer, if it ever reach us, it must spring up amongst us. It cannot come from abroad. If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all time, or die by suicide. I hope I am over-wary, but if I am not, there is even now something of ill omen amongst us. I mean the increasing disregard for law which pervades the country. The growing disposition to substitute the wild and furious passions in lieu of the sober judgment of courts, and the worse than savage mobs for the executive ministers of justice. They have pervaded the country from New England to Louisiana. It would be tedious as well as useless to recount the horrors of all of them.
In the part that I've edited out here, he talks about the death of two people, a gambler and a murderer. And as he says, they particular incidents, while they're crimes, might not seem to be terribly concerning because there's crime all the time anyway. But what he's going to go on to talk about is the significance of what he sees as a tendency towards mob law.
Such are the effects of mob law, and such as the scenes becoming more and more frequent in this land so lately famed for love of law and order, and the stories of which have even now grown too familiar. But you are perhaps ready to ask, what is this to do with the perpetuation of our political institutions? I answer, it has much to do with it. Its direct consequences are, comparatively speaking, but a small evil, and much of its danger consists in the proneness of our minds to regard its direct as its only consequences. Abstractly considered, the hanging of the gamblers at Vicksburg was of but little consequence. They constitute a portion of population that is worse than useless in any community, and their death, if no pernicious example be set by it, is never matter of reasonable regret with anyone. The innocent, those who have ever set their faces against violations of law in every shape, alike with the guilty, fall victims to the ravages of mob law. And thus it goes on, step by step, till all the walls erected for the defense of the persons and property of individuals are trodden down and disregarded. But all this even is not the full extent of the evil. By such examples, by instances of the perpetrators of such acts going unpunished, the lawless in spirit are encouraged to become lawless in practice, and having been used to no restraint, but dread of punishment, they thus become absolutely unrestrained. Having ever regarded government as their deadliest bane, they make a jubilee of the suspension of its operations, and pray for nothing so much as its total annihilation. While on the other hand, good men, men who love tranquility, who desire to abide by the laws and enjoy their benefits, who would gladly spill their blood in the defense of their country, seeing their property destroyed, their families insulted, and their lives endangered, their persons injured, and seeing nothing in prospect that forebodes a change for the better, become tired of and disgusted with a government that offers them no protection, and are not much averse to change in which they imagine they have nothing to lose. Thus, then, by the operation of this mobocratic spirit, which all must admit is now abroad in the land, the strongest bulwark of any government, and particularly of those constituted like ours, may effectually be broken down and destroyed. I mean the attachment of the people. Whenever this effect shall be produced among us, whenever the vicious portion of population shall be permitted to gather in bands of hundreds and thousands, and burn churches, ravage and rob provision stores, throw printing presses into rivers, shoot editors, and hang and burn obnoxious persons at pleasure, and with impunity, depend upon it, this government cannot last. By such things, the feelings of the best citizens will become more or less alienated from it, and thus it will be left without friends, or too few, with those few too weak to make their friendship effectual. At such a time, and under such circumstances, men of sufficient talent and ambition will not be wanting to seize the opportunity, strike the blow, and overturn that fair fabric which for the last half-century has been the fondest hope of the lovers of freedom throughout the world. I know the American people are much attached to their government. I know they would suffer much for its sake. I know they would endure evils long and patiently before they would ever think of exchanging it for another. Yet notwithstanding all this, if the laws be continually despised and disregarded, if their rights to be secure in their persons and property are held by no better tenure than the caprice of a mob, the alienation of their affections from the government is the natural consequence, and to that, sooner or later, it must come. Here, then, is one point at which danger may be expected.
What he's saying about mob law ought to concern us today. If he were alive today and looked at the social media mobs, what would he think? Moreover, in 2020, we saw a lot of mob violence. And the point about it threatening the innocent, and if the innocent will lose their attachment to the notion that government will actually protect them, that's very destabilizing. So what do you do about it? Let's go forward.
The question recurs, how shall we fortify against it? The answer is simple. Let every American, every lover of liberty, every well-wisher to his posterity, swear by the blood of the Revolution never to violate, in the least particular, the laws of the country, and never to tolerate their violation by others. As the patriots of '76 did to the support of the Declaration of Independence, so to the support of the Constitution and laws, let every American pledge his life, his property, and his sacred honor. Let every man remember that to violate the law is to trample on the blood of his father, and to tear the character of his own and his children's liberty. Let reverence for the laws be breathed by every American mother to the lisping babe that prattles on her lap. Let it be taught in schools, in seminaries, and in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in courts of justice. And in short, let it become the political religion of the nation, and let the old and the young, the rich and the poor, the grave and the gay, of all sexes and tongues and colors and conditions, sacrifice unceasingly upon its altars. While ever a state of feeling such as this shall universally or even very generally prevail throughout the nation, vain will be every effort and fruitless every attempt to subvert our national freedom. When I so pressingly urge a strict observance of all the laws, let it not be understood as saying there are no bad laws, nor that grievances may not arise, for the redress of which no legal provisions have been made. I mean to say no such thing. But I do mean to say that, although bad laws, if they exist, should be repealed as soon as possible, still, while they continue in force for the sake of example, they should be religiously observed. There is no grievance that is a fit object of redress by mob law. As any case that arises, as, for instance, the promulgation of abolitionism, one or two positions is necessarily true. That is, the thing is right within itself, and therefore deserves the protection of all law and all good citizens. Or it is wrong, and therefore proper to be prohibited by legal enactments. And in either case is the interposition of mob law either necessary, justifiable, or excusable. But it may be asked, why suppose danger to our political institutions? Have we not preserved them for more than 50 years, and why may we not for 50 times as long? We hope there is no sufficient reason. We hope all dangers may be overcome, but to conclude that no danger may ever arise would itself be extremely dangerous. There are now, and will hereafter be, many causes, dangerous in their tendency, which have not existed before, and which are not too insignificant to merit attention. That our government should have been maintained in its original form from its establishment until now is not much to be wondered at. It had many props to support it through that period, which are now decayed and crumbled away. Through that period, it was felt by all to be an undecided experiment. Now it is understood to be a successful one. Then all that sought celebrity and fame and distinction expected to find them in the success of that experiment. Their all was staked upon it. Their destiny was inseparably linked with it. Their ambition aspired to display before an admiring world a practical demonstration of the truth of a proposition which had hitherto been considered, at best, no better than problematical. namely, the capability of a people to govern themselves. If they succeeded, they were to be immortalized. Their names were to be transferred to counties and cities, and rivers and mountains, and to be revered and sung and toasted through all time. If they failed, they were to be called knaves and fools and fanatics for a fleeting hour, then to sink and be forgotten. They succeeded. The experiment is successful, and thousands have won their deathless names in making it so. But the game is caught, and I believe it is true that with the catching end the pleasures of the chase. This field of glory is harvested, and the crop is already appropriated. But new reapers will arise, and they too will seek a field. It is to deny what the history of the world tells us is true, to suppose that men of ambition and talents will not continue to spring up amongst us. And when they do, they will as naturally seek the gratification of their ruling passion, as others have done so before them. The question then is, can that gratification be found in supporting and maintaining an edifice that has been erected by others? Most certainly it cannot. Many great and good men sufficiently qualified for any task they should undertake may ever be found, whose ambition would inspire to nothing beyond a seat in Congress, a gubernatorial or a presidential chair. But such belong not to the family of the lion or the tribe of the eagle. What? Think you these places would satisfy an Alexander, a Caesar, or a Napoleon? Never. Towering genius disdains a beaten path. It seeks regions hitherto unexplored. It sees no distinction in adding story to story upon the monuments of fame erected to the memory of others. It denies that it is glory enough to serve under any chief. It scorns to tread in the footsteps of any predecessor, however illustrious. It thirsts and burns for distinction, and if possible, it will have it, whether at the extreme of emancipating slaves or enslaving free men. It is unreasonable then to expect that some man possessed of the loftiest genius, coupled with ambition sufficient to push it to its utmost stretch, will at some time spring up amongst us. And when such a one does, it will require the people to be united with each other, attached to the government and laws, and generally intelligent to successfully frustrate his designs.
Lincoln's emphasis that you just heard on the blood of the revolution and swearing by that to maintain a commitment to the rule of law is extremely significant, because in this next section, he's going to talk about how our loyalty or familiarity or whatever you want to call it to the founders will necessarily and has necessarily faded over time. It's a generational thing. People that are no longer alive who were present at the founding, they're not there to remind us. So what's going to substitute for that in a nation that maybe can't be conquered from abroad, but has to maintain an internal cohesiveness if it is to last? And he's worried about it lasting.
Distinction will be his paramount object, and although he would as willingly, perhaps even more so, acquire it by doing good as harm, yet that opportunity being past and nothing left to be done in the way of building up, he would set boldly to the task of pulling down. Here then is a probable case, highly dangerous, and such a one as could not have well existed before. Another reason which once was, but which to the same extent is now no more, has done much in maintaining our institutions thus far. I mean the powerful influence which the interesting scenes of the Revolution had upon the passions of the people as distinguished from their judgment. By this influence, the jealousy, envy, and avarice incident to our nature, and so common to a state of peace, prosperity, and conscious strength, were, for the time, in a great measure smothered and rendered inactive. But this state of feeling must fade, is fading, has faded, with the circumstances that produced it. I do not mean to say that the scenes of the Revolution are now or ever will be entirely forgotten, but that, like everything else, they must fade upon the memory of the world, and grow more and more dim by the lapse of time. In history, we hope they will be read of and recounted, so long as the Bible shall be read. But even granting that they will, their influence cannot be what it heretofore has been. Even then, they cannot be so universally known, nor so vividly felt, as they were by the generation just gone to rest. But those histories are gone. They can be read no more forever. They were a fortress of strength, but what invading foemen could never do, the silent artillery of time has done, the leveling of its walls. They are gone. They were the pillars of the temple of liberty, and now that they have crumbled away, that temple must fall, unless we, their descendants, supply their places with other pillars, hewn from the solid quarry of sober reasons. Passion has helped us, but can do so no more. It will in future be our enemy. Reason, cold, calculating, unimpassioned reason, must furnish all the materials for our future support and defense. Let those materials be molded into general intelligence, sound morality, and in particular, a reverence for the Constitution and laws. And that we improved to the last, that we remained free to the last, that we revered his name to the last, that during his long sleep we permitted no hostile foot to pass over or desecrate his resting place, shall be that which to learn the last trump shall awaken our Washington. Upon these let the proud fabric of freedom rest, as the rock of its basis, and as truly as has been said of the only greater institution, the gates of hell shall not prevail against it.
I want to read one line exactly as it is delivered here for the purpose of emphasis. Passion has helped us, but can do so no more. It will in future be our enemy. Reason, cold, calculating, unimpassioned reason must furnish all the materials for our future support and defense. We could spend a long time discussing that, but it is largely in response, I believe, to what he had gone through earlier in one of the readings here that I didn't comment on, or I didn't comment on that part of it. And that is that ambitious men will arise. And since the country has been such a success, what is it that ambitious men want to do? They want to make their marks somehow. And how does he predict they might make it? By destroying that which has been built. Now, talking about ambitious men reflects that Lincoln really does understand human nature. And unlike modern day politicians who may understand it at its basis level, he understands it at many levels. And one wonders, is he looking inside of himself and seeing his own ambition? And what will he do? Well, fortunately for the Union, he largely, with a possible exception or two, did the right thing. But now, let's turn to Frederick Douglass, whom Lincoln meets in 1863. All conservatives should be very familiar with this speech by Frederick Douglass. He is an originalist textualist long before Justice Scalia is ever born. The fact that he emphasizes it so much in this speech is not only a tribute to the fact that Justice Scalia stands in a long history, but that the argument against textualism is that racism requires that we ignore the text. And it's just the opposite argument that Douglass is making. It is necessary, if not for other reasons as well, to be a textualist in order to defeat slavery. The modern living constitutionalists who use the race card against the text of the Constitution basically are making the argument of the Garrisonians, that is, the opponent of Garrison, who he was once allied with him. But after 1851, they split, or in 1851, they split because Garrison and his followers want to separate. They want to secede from the South. And Douglass is all against it. Douglas changes his mind on the Constitution from a view that he held earlier, and he admits that he's learning as he goes along. And in this speech, he is very much arguing as a very good lawyer, but he wasn't a lawyer. That reflects the fact that the Constitution was written for ordinary laymen to be able to read and understand. And of course, lawyers and judges gloss the Constitution with cases, and that makes it more and more difficult for ordinary Americans to understand what is being said in the name of the Constitution and whether it is or isn't valid. Professor Barnett, on page 51 of our Republican Constitution, he mentions a largely unknown lawyer named Lysander. I forget his last name. It's on page 91. Lysander Spooner, he makes the argument that Douglas is going to make. Maybe it was, I presume, that Douglas got the argument by learning about Spooner's argument that failed in court. Nevertheless, it is a very important argument. Let's hear it. And this is read by Hector Donald Edward Lewis.
I proceed to the discussion. And first, a word about the question. Much will be gained at the outset if we fully and clearly understand the real question under discussion. Indeed, nothing is or can be understood. These are often confounded and treated as the same for no better reason than that they resemble each other, even while they are in their nature and character totally distinct and even directly opposed to each other. This jumbling up things is a sort of dust throwing which is often indulged in by small men who argue for victory rather than for truth. Thus, for instance, the American government and the American Constitution are spoken of in a manner which would naturally lead the hearer to believe that one is identical with the other, when the truth is they are distinct in character as is a ship and a compass. The one may point right and the other steer wrong. A chart is one thing. The course of the vessel is another. The Constitution may be right. The government is wrong. If the government has been governed by mean, sordid, and wicked passions, it does not follow that the Constitution is mean, sordid, and wicked. What then is the question? I will state it. But first let me state what is not the question. It is not whether slavery existed in the United States at the time of the adoption of the Constitution. It is not whether slaveholders took part in the framing of the Constitution. It is not whether those slaveholders in their hearts intended to secure certain advantages in that instrument for slavery. It is not whether the American government has been wielded during 72 years in favor of the propagation and the permanence of slavery. It is not whether a pro-slavery interpretation has been put upon the Constitution by the American courts. All these points may be true or they may be false. They may be accepted or they may be rejected without in any wise affecting the real question in debate. The real and exact question between myself and the class of persons represented by the speech at the City Hall may be fairly stated thus. First, does the United States Constitution guarantee to any class or description of people in that country the right to enslave or hold as property any other class or description of people in that country? Second, is the dissolution of the union between the slave and free states required by fidelity to the slaves or by the just demands of conscience? Or, in other words, is the refusal to exercise the elective franchise and to hold office in America the surest, wisest, and best way to abolish slavery in America? To these questions, the Garrisonians say yes. They hold the Constitution to be a slave-holding instrument and will not cast a vote or hold office and denounce all who vote or hold office, no matter how faithfully such persons labor to promote the abolition of slavery. Now, on the other hand, deny that the Constitution guarantees the right to hold property in man and believe that the way to abolish slavery in America is to vote such men into power, as well use their powers for the abolition of slavery. This is the issue plainly stated, and you shall judge between us.
Although Douglas is not in a face-to-face debate, he is responding to another speaker who had appeared elsewhere in the same city, apparently, and that person was making the argument that the Constitution is pro-slavery. Now, in the part that I've edited out here, what Douglas does is actually to read the specific parts of the Constitution to which the other speaker is referring. We're going to put those up on the side so you can actually see them. But rather than reading them, we'll go through Douglas referring to them, and you'll be able to tell which of them he's referring to as we go along.
Here then are those provisions of the Constitution which the most extravagant defenders of slavery can claim to guarantee a right of property in man. These are the provisions which have been pressed into the service of the human fleshmongers of America. Let us look at them just as they stand, one by one. Let us grant, for the sake of the argument, that the first of these provisions, referring to the basis of representation and taxation, does refer to slaves. We are not compelled to make that admission, for it might fairly apply to aliens, a person living in the country, but not naturalized. But giving the provisions the very worst construction, what does it amount to? I answer, it is a downright disability laid upon the slaveholding states, one which deprives those states of 2/5 of their natural basis of representation. A black man in a free state is worth just 2/5 more than a black man in a slave state, as a basis of political power under the Constitution. Therefore, instead of encouraging slavery, the Constitution encourages freedom by giving an increase of 2/5 of political power to free over slave states. So much for the 3/5 clause. Taking it at its worst, it still leans to freedom, not slavery. For be it remembered that the Constitution nowhere forbids a colored man to vote. I come to the next, that which it is said guaranteed, the continuance of the African slave trade for 20 years. I will also take that for just what my opponent alleges it to have been, although the Constitution does not warrant any such conclusion. But to be liberal, let us suppose it did, and what follows? Why this, that this part of the Constitution, so far as the slave trade is concerned, became a dead letter more than 50 years ago, and now binds no man's conscience for the continuance of any slave trade whatsoever. Mr. Thompson is just 52 years too late in dissolving the Union on account of this clause. But there's still more to be said about this abolition of the slave trade. Men at that time, both in England and America, looked upon the slave trade as the life of slavery. The abolition of the slave trade was supposed to be the certain death of slavery. Cut off the stream, and the pond will dry up, was the common notion at the time.
In an earlier session, I quoted from Professor Barnett's book about the fact that when the Constitution was drafted, it was clearly thought that slavery would die out, but then the cotton gin and steamboat came along and changed the economics of slave labor. And then I cited the Northwest Ordinance. But the best information or support for that position really comes from what Frederick Douglass is saying.
Wilberforce and Clarkson, clear-sighted as they were, took this view, and the American statesmen, in providing for the abolition of the slave trade, thought they were providing for the abolition of the slavery. This view is quite consistent with the history of the times. All regarded slavery as an expiring and doomed system, destined to speedily disappear from the country. But again, it should be remembered that this very provision, if made to refer to the African slave trade at all, makes the Constitution anti-slavery rather than for slavery. For it says to the slave states, the price you will have to pay for coming into the American Union is that the slave trade, which you would carry on indefinitely out of the Union shall be put an end to in 20 years if you come into the Union. Secondly, if it does apply, it expired by its own limitation more than 50 years ago. Thirdly, it is anti-slavery because it looked to the abolition of slavery rather than to its perpetuity. Fourthly, it showed that the intentions of the framers of the Constitution were good, not bad. I think this is quite enough for this point. I go to the Slave Insurrection Clause, though in truth there is no such clause. The one which is called so has nothing whatever to do with slaves or slaveholders any more than your laws for suppression of popular outbreaks has to do with making slaves of you and your children. It is only a law for suppression of riots or insurrections. Thus, you see the so-called slave-holding provisions of the American Constitution, which a little while ago looked so formidable, are, after all, no defense or guarantee for slavery whatever.
When I first started to look at Frederick Douglass and looking at his arguments, the hardest argument I thought was this last one, but it's interesting the way he handles it. It's both text, but then he's going to go into the minutes of the Constitutional Convention. But I thought we were supposed to just look at text. Why is he going into the Constitutional Convention? Well, as a debating point, he is rebutting the actual argument of the other. He's willing to rely simply on the text. The other's not, and he is driving the stake even deeper in terms of his argument. And really has to, because this particular clause, generally called the Fugitive Slave Clause, is probably the hardest of the arguments to rebut. But let's hear it.
But there is one other provision. This is called the Fugitive Slave Provision. It is called so by those who wish to make it subserve the interest of slavery in America, and the same by those who wish to uphold the views of a party in this country. Now, what are the facts connected with this provision of the Constitution? You shall have them. It is quite true that Mr. Butler and Mr. Pinckney introduced a provision expressly with a view to the recapture of fugitive slaves. It is quite true also that there was some discussion on the subject. And just here the truth shall come out. These illustrious kidnappers were told promptly in that discussion that no such idea as property in man should be admitted into the Constitution. The speaker in question might have told you, and he would have told you but the simple truth, if he had told you that the proposition of Mr. Butler and Mr. Pinckney, which he leads you to infer was adopted by the convention that from the Constitution, was, in fact, promptly and indignantly rejected by that convention. He might have told you, had it suited his purpose to do so, that the words employed in the first draft of the Fugitive Slave Clause were such as applied to the condition of slaves, and expressly declared that persons held to servitude should be given up, but that the word servitude was struck from the provision for the very reason that it applied to slaves. He might have told you that the same Mr. Madison declared that the word was struck out because the convention would not consent that the idea of property in men should be admitted into the Constitution. The fact that Mr. Madison can be cited on both sides of this question is another evidence of the folly and absurdity of making the secret intentions of the framers the criterion by which the Constitution is to be construed. But it may be asked, if this clause does not apply to slaves, to whom does it apply?
It's interesting that he notes that Madison is the one who is relating, of course, in Madison's notes, that the convention rejected the idea of property in a human being, a man. But then he notes that Madison was inconsistent, and that's one of the reasons why you can't really trust what people say about a text rather than reading the text yourself. And so he's going to give a very interesting, and I think very persuasive explanation of why the text itself doesn't include slaves in what has been dubbed the fugitive slave law or fugitive slave part of the Constitution.
I answer that, when adopted, it applies to a very large class of persons, namely redemptionists, persons who had come to America from Holland, from Ireland, and other quarters of the globe, like the coolies to the West Indies, and had, for consideration duly paid, become bound to serve and labor for the parties to whom their service and labor was due. It applies to indentured apprentices and others who have become bound for consideration, under contract duly made, to serve and to labor. To such persons this provision applies, and only to such persons. The plain reading of this provision shows that it applies, and that it can only properly and legally apply to persons bound to service. Its object plainly is to secure the fulfillment of contracts for service and labor. It applies to indentured apprentices and other persons for whom service and labor may be due. The legal condition of the slave puts him beyond the operation of this provision. He is not described in it. He is a simple article of property. He does not owe and cannot owe service. He cannot even make a contract. It is impossible for him to do so. He can no more make such a contract than a horse or an ox can make one. This provision then only respects persons who owe service, and they only can owe service who can receive an equivalent and make a bargain. The slave cannot do that, and it is therefore exempted from the operation of this fugitive provision. In all matters where laws are taught to be made the means of oppression, cruelty, and wickedness, I am for a strict construction. I will concede nothing. It must be shown that it is so nominated in the bond, the pound of flesh, but not one drop of blood. The very nature of law is opposed to all such wickedness and makes it difficult to accomplish such objects under the forms of law. Law is not merely an arbitrary enactment with regard to justice, reason, or humanity. Blackstone defines it to be a rule prescribed by the supreme power of the state, commanding what is right and forbidding what is wrong. The Speaker at the City Hall laid down some rules of legal interpretation. These rules send us to the history of the law for its meaning. I have no objection to such a course in ordinary cases of doubt, but where human liberty and justice are at stake, the case falls under an entirely different class of rules. There must be something more than history, something more than tradition.
As I said earlier, the most difficult part, it seems to me, of Douglas's explanation of why there's no reference to slavery in the Constitution is not the fact that there is no reference. That's true. But this clause that's been dubbed the Fugitive Slave Clause, and it doesn't use that term, how should it be interpreted? Now, what Douglas is going to give is a mode of interpretation that sounds very much like Justice Scalia in many ways. So what did I do? I went back to Justice Scalia's book, Reading Law, that he wrote with Brian Garner. And there's no specific reference that I could find to this part of the Constitution as an example or anything else. So there is discussion about what to do with an ambiguity and what constitutes an ambiguity. I think, of course, that Douglas's strongest argument is that it's clear it's not an ambiguity. But in case there is an ambiguity, what do? Well, the two authors, Justice Scalia and Garner, say they adopt the fair reading approach. Well, that indicates that there's more than one approach, but let's stick with the fair reading. First of all, you have to find there's an ambiguity. And if you can't decide as between the two, then you look to context and purpose. And that's where we'll have to leave it. But let's listen as Douglas explains how he would interpret it.
The Supreme Court of the United States lays down this rule, and it meets the case exactly. Where rights are infringed, where the fundamental principles of the law are overthrown, where the general system of the law is departed from, The legislative intention must be expressed with irresistible clearness. The same court says that the language of the law must be construed strictly in favor of justice and liberty. Again, there is another rule of law. It is, where law is susceptible of two meanings, the one making it accomplish an innocent purpose, and the other making it accomplish a wicked purpose, we must in all cases adopt that which makes it accomplish an innocent purpose. Again, the details of a law are to be interpreted in the light of the declared objects sought by the law. I set these rules down against those employed at the City Hall. To me, they seem just and rational. I only ask you to look at the American Constitution in light of them, and you will see with me that no man is guaranteed a right of property in man under the provisions of that instrument. If there are two ideas more distinct in their character and essence than another, these ideas are persons and property, men and things. Now, when it is proposed to transform persons into property and men into beasts of burden, I demand that the law that completes such a purpose shall be expressed with irresistible clearness. The thing must not be left to inference, but must be done in plain English. Let us look at the objects for which the Constitution was framed and adopted, and see if slavery is one of them. Here are its own objects as set forth by itself. We, the people of these United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. The objects here set forth are 6 in number: union, defense, welfare, tranquility, justice, and liberty. These are all good objects, and slavery, so far from being among them, is a foe of them all.
The next section, which follows right on, argues that slaves are in the category of people intended to be benefited by the Constitution. I think it's pretty clear that the way that slavery was kept out of the Constitution was designed with a view that eventually they would benefit from the Constitution itself. He's arguing in a way, though, that's interesting, because the fact that 3/5 of slaves are counted means they are, quote, represented. Now, the people designated to represent them, even though they didn't vote for them, they can still be represented, just as women were represented, even though they couldn't vote. But they're represented in a way, theoretically. They're not in fact being represented, but the fact that they are being represented means that members of Congress from elsewhere could argue on their behalf, and they did. So what's the argument? Well, the argument is, one, they're persons, and two, they're counted in the census and they're represented. So why aren't they entitled to all of the rights otherwise for those who are not white males at this point? Because that criterion for voting is really set by the states at this point.
But it has been said that Negroes are not included within the benefits sought under this declaration. It is said by the slaveholders in America. It is said by the City Hall orator. But it is not said by the Constitution itself. Its language is "we the people." Not we the white people, not we the citizens, not we the privileged class, not we the high, not we the low, but we the people. Not we the horses, sheep, and swine, and wheelbarrows, but we the people, we the human inhabitants, and if Negroes are people, they are included in the benefits for which the Constitution of America was ordained and established. But how dare any man who pretends to be a friend of the Negro thus gratuitously concede away that the Negro has a right to claim under the Constitution? Why should such friends invent new arguments to increase the hopelessness of his bondage? This I undertake to say, as the conclusion of the whole matter, that the constitutionality of slavery can be made out only by disregarding the plain and common sense reading of the Constitution itself, by discrediting and casting away as worthless the most beneficent rules of legal interpretation, by ruling the Negro outside of these beneficent rules, by claiming that the Constitution does not mean what it says, and that it says what it does not mean, by disregarding the written Constitution and interpreting it in the light of a secret understanding. It is in this mean, contemptible, and underhanded method that the American Constitution is pressed into the service of slavery. They go everywhere else for proof that the Constitution declares that no person shall be deprived of life, liberty, or property without due process of law. It secures to every man the right of trial by jury, the privilege of the writ of habeas corpus, the great writ that put an end to slavery and slave hunting in England. And it secures to every state a republican form of government. Any one of these provisions in the hands of abolition statesmen and backed up by a right moral sentiment would put an end to slavery in America. The Constitution forbids the passing of a bill of attainder, that is, a law entailing upon the child the disabilities and hardships imposed upon the parent. Every slave law in America might be repealed on this very ground. The slave is made a slave because his mother is a slave. But to all this, it is said that the practice of the American people is against my view. I admit it. They have given the Constitution a slave-holding interpretation. I admit it. They have committed innumerable wrongs against the Negro in the name of the Constitution. Yes, I admit it all. And I go with them who goes farthest in denouncing these wrongs. But it does not follow that the Constitution is in favor of these wrongs because the slaveholders have given it that interpretation. To be consistent in his logic, the City Hall Speaker must follow the example of some of his brothers in America. He must not only fling away the Constitution, but the Bible. The Bible must follow the Constitution, for that too has been interpreted for slavery by American divines.
Douglas is speaking in early 1860. The war is about to be upon us. And he says in this section, not only that the North should not split from the South or let the South split from the North, but that the North has a responsibility because, after all, it had a role in the slave trade. Interesting, because it also implies ultimately that winning the war at the cost of great blood and treasure, there's been a lot paid in terms of the debt owed. And he's very instructive on this point of the obligation.
My argument against the dissolution of the American Union is this. It would place the slave system more exclusively under the control of the slaveholding states and withdraw it from the power in the northern states, which is opposed to slavery. Slavery is essentially barbarous in its character. It, above all else, dreads the presence of an advanced civilization. It flourishes best where it meets no reproving frowns and hears no condemning voices. While in the Union, it will meet with both. Its hope of life, in the last resort, is to get out of the Union. I am therefore for drawing the bond of the Union more completely under the power of the free states. What they most dread, that I most desire. I have much confidence in the instincts of the slaveholders. They see that the Constitution will afford slavery with no protection when it shall cease to be administered by slaveholders. They see, moreover, that if there is once a will in the people of America to abolish slavery, this is no word, no syllable in the Constitution to forbid that result. They see that the Constitution has not saved slavery in Rhode Island and Connecticut and New York or Pennsylvania, that the free states have only added 3 to their original number. There were 12 slave states at the beginning of the government. There are 15 now. The dissolution of the Union would not give the North a single advantage over slavery, but would take from it many. Within the Union, we have a firm basis of opposition to slavery. It is opposed to all the great objects of the Constitution. The dissolution of the Union is not only an unwise but a cowardly measure. 15 million running away from 350,000 slaveholders. Mr. Garrison and his friends tell us that while in the Union, we are responsible for slavery. He and they sing out, "No union with slaveholders," and refuse to vote. I admit our responsibility for slavery while in the Union, but I deny that going out of the Union would free us from that responsibility. There now clearly is no freedom from responsibility for slavery to any American citizen short to the abolition of slavery. The American people have gone quite too far in this slaveholding business now to sum up their whole business of slavery by singing out the cant phrase, "No union with slaveholders." The American people in the northern states have helped to enslave the black people. Their duty will not have been done until they give them back their plundered rights.
In this closing part of his speech, he addresses the fact that others will say and have said that he has changed his mind. And he admits that he has, and he has no problem saying so, that he was under the influence of the Garrisonians, but he has learned from his own study that he disagrees with them. This is a wonderful testament to making knowledge fully available. That means not suppressing speech. Indeed, much of what's happening today in this country, we can call the new Garrisonians. Certainly it's been that way in law school for a long time, since many constitutional law professors make the Garrisonian argument against the Constitution. But now in grade schools, in secondary schools, the arguments are being pushed into the educational stream that basically everything about America is tainted and wrong. Well, Frederick Douglass is the one to turn to and read.
Reference was made at the City Hall to my having once held other opinions, and very different opinions to those I have now expressed. An old speech of mine delivered 14 years ago was read to show, I know not what. Perhaps it was to show that I am not infallible. If so, I have to say in defense that I never pretended to be. Although I cannot accuse myself of being remarkably unstable, I do not pretend that I've never altered my opinion both in respect to men and things. Indeed, I've been very much modified both in feeling and opinion within the last 14 years. When I escaped from slavery and was introduced to the Garrisonians, I adopted very many of their opinions and defended them just as long as I deemed them true. I was young, had read but little, and naturally took some things on trust. Subsequent experience and reading have led me to examine for myself. This had brought me to other conclusions. When I was a child, I thought and spoke as a child, but the question is not as to what were my opinions 14 years ago, but what are they now? If I am right now, it really does not matter what I was 14 years ago. My position now is one of reform, not of revolution. I would act for the abolition of slavery through the government, not over its ruins. If slaveholders have ruled the American government for the last 50 years, let the anti-slavery men rule the nation for the next 50 years. If the South has made the Constitution bend to the purposes of slavery, let the North now make that instrument bend to the cause of freedom and justice. If 350,000 slaveholders have, by devoting their energies to that single end, been able to make slavery the vital and animating spirit of the American Confederacy for the last 72 years, now let the freemen of the North, who have the power in their own hands, and who can make the American government just what they think fit, resolve to blot out forever the foul and haggard crime, which is the blight and mildew, the curse and the disgrace of the whole United States.
Less than 3 months after Douglass's speech, the Civil War officially began. And people who remember anything from high school or grade school about this should remember it was the bloodiest war the United States has ever been involved in. The number of deaths was about 620,000 at least. Others suggest higher. Total casualties, military casualties, were 1.5 million In terms of the population, that was about 2% of the population. Today, in terms of this, that percentage would be a much higher number. Well, why? Why was it so terribly, terribly bloody? Well, this was actually predicted in the Federalist Papers, that if we ever got into a civil war. So let me read a little bit from Federalist number 8 in the argument of why we needed the Union and to keep it together. The Federalist writes, war between the states in the first period of their separate existence would be accompanied with much greater distresses than is commonly in those countries where regular military establishments have long obtained. So what does he then describe? He describes the fact that in Europe, there are fortifications. And because of these fortifications, even though they suppress liberty, they make it very difficult for an army to move across or to move across quickly. But that's not the situation that it will be within the United States if a war ever comes. In this country, the scene would be altogether reversed. The jealousy of military establishments would postpone them as long as possible. The want of fortifications, leaving the frontiers of one state open to another, would facilitate inroads. The populous states would, with little difficulty, overrun their less populous neighbors. Conquest would be as easy to be made as difficult to be retained. War, therefore, would be desultory and predatory. Plunder and devastation ever march in the train of irregulars. The calamities of individuals would make the principal figure in the events which would characterize our military exploits. Now, there was a little more sophistication in the troops by the time of the Civil War, but armies were running up and down because there weren't any fortifications. That added to the bloodshed. And on top of all this, what did it do to the psyche of the American people? It was devastating. And what does it do to the ambitious men that Lincoln described? He talked about ambitious men destroying so they could build anew. Well, here, the destruction was done by both sides. And we're going to see in the next session a little bit of what happens and the very big departure, in fact, from the whole trend that spanned the period from before the Revolution, through the Declaration, through the Constitution, and through the struggle to keep the Union together. So the readings for the next session are as follows. So I'm asking you to review certain pages that we've already gone over from our Republican Constitution. That's pages 44 to 51. And related to that is the article that I wrote that's up there about the natural and the positive in American law. What happens after the Civil War is actually a change in the understanding of what the word law means, and ultimately a change in the way law students are taught to be lawyers. In addition to that, it would be a good idea, if you haven't already read it, to look at and look over chapter 5 in our Republican Constitution. So in chapter 4, which we've already assigned and gone over some of it, there is the good part about what happens in the slavery and the war issue, and that is the production of the post-Civil War amendments. But then Professor Barnett goes into the undermining of the Republican elements of it. And all of that is going to work together with other changes that are occurring that we'll go into in the next session. Thank you for joining us this week, and we look forward to seeing you next week.